5 seconds to go. Start. At the same time, there may be a situation as being projected by the appellant to this court that in special cases where a pregnant lady may not be in a position and is unable to complete her medical examination within a period of 6 months, in the peculiar circumstances, the word ordinarily may be considered for relaxation to a limited extent, but the kind of excuse which has been projected by the respondent applicant that though he was found to be temporarily unfit, but the consolidated reserve list was published on 19th January 2016, where his name was placed at serial number 16 and allotment to Group A services was published on 9th March 2016. He immediately filed an application on 10th March 2016 without loss of time, which was within the prescribed period of 6 months from the date of publication of the reserve list. In our considered view, is neither a valid justification nor is in conformity with the scheme of rules of which a reference has been made. In our considered view, the word ordinarily in isolation as interpreted by the High Court without taking recourse to the word maximum as referred is not sustainable in law. It is true that the case of the respondent applicant on legal foundation is not sustainable, but we are constrained to observe that it was the fifth and last attempt of the respondent applicant during which he appeared in CSC 2014, and it is not disputed that before the year 2014 examinations which were conducted by the appellant, medical report was always made available to the individual candidate, and it is only for the first time in the year 2014 this clause was inserted where the medical reports are being uploaded on the website of the department, which was considered to be the notice to all the candidates who had participated in the selection process, which might have created some confusion with the respondent applicant. And once his name found place in the consolidated reserve list in January 2016, he made a representation on 10th March 2016 along with his medical fitness certificate, and after the orders of this court, the respondent applicant has again been sent for re-medical examination and has been found medically fit for all services as it reveals from the medical report dated 12th May 2022. In the given circumstances, this court, while exercising its plenary power under Article 142 of the Constitution to do complete justice, consider it appropriate to direct that based on the re-medical fitness report, the appellant may consider the case of the respondent applicant for appointment as per his placement in the consolidated reserve list originally published of CSC 2014 on 19th January 2016, subject to police verification with all notional benefits including seniority, pay scale and other consequential benefits, but not the actual salary for the period for which he has not worked within a period of 4 weeks from today. Consequently, the appeal succeeds and is allowed. The judgment of the High Court impugned, dated 6th April 2021, is accordingly quashed and set aside with the observations made above. No cause. Stop.